Hey everybody, Deanna here with Employers Advantage. There's a lot happening with employment law, employee compliance, and it's going to have a really big impact on small businesses. These rules apply to virtually every business in existence, regardless of the size. And so, specifically for our small businesses, we really want to talk about what this means and how can you be compliant and what you'll need to do going forward. So this is going to be a very, very busy summer, making sure that these new regulations are put into play at your business, and we want to help with that as much as we can. So the first one is under the Fair Labor Standards Act. There are a few what they call exemptions in which a role can apply or qualify for this exemption where they're not eligible for overtime. The majority of positions technically should be eligible for overtime. And then there's some buckets: administrative, executive, computer outside sales. There's a couple exemptions in which a role could be made exempt from overtime eligibility. The first test in determining if a role is eligible for exemption is the salary they receive. Currently, the minimum salary threshold is $35,568. That is going to be increased as of July 1st to $43,888. It's a pretty big jump. And what that means is if you have anybody that is currently being paid a salary of $43,808 or under $43,888, then the position needs to be reviewed and determined, is this position hourly non-exempt, which means they would then be eligible for overtime, or is this really an exempt position? And if so, then their salary needs to be increased to that minimum, to that $43,888. But then we also want to make sure that the position is meeting the other duties required to meet the exemption. And one thing I want to point out here too is how somebody is paid doesn't determine if they're eligible for overtime or not. It's the duties test in addition to the salary minimum. So somebody could still be paid a salary and eligible for overtime. So we just need to make sure that that's clear. Hourly and salary does not determine whether they're eligible for overtime or not. The what's called exemption status does, whether they're exempt or non-exempt. Exempt means they meet the minimum salary threshold and the duties tests, and they're not eligible for overtime. If they don't meet the minimum salary and the duties tests, they're non-exempt and eligible for overtime. So if you've got somebody that's in that category and maybe they are going to be switched to hourly non-exempt, that's going to be a big change. And so they're going to switch to having to track their time, probably be managed a little bit differently. They'll need to understand overtime policies, what's approved, what's not approved, how to manage their time, things like that. So it's going to be a pretty significant change. The effective date for this is July 1st of 2024. So we strongly encourage companies to take a look at who might this impact at their companies now and get those changes made as soon as possible. Now, looking forward, January 1, they're anticipating that it's going to increase again to $58,656. So we'll have to go through the same exercise again at that time. But let's first pay attention to the July 1 date and then see what happens through the rest of the year, because you just never know. Lawsuits happen, things change. So let's focus on the July 1 date, and then we'll go from there. The second biggest thing that's happening is there's a ban on non-competes. Now, the effective date for that is not until September 4th. So what that means is anybody who has non-compete language in any agreements, severance agreements, new hire documents, handbooks, policies, whatever the case may be, those will need to be eliminated. Now, that applies to both employees and independent contractors. So that's something to keep in mind too. What's going to happen is all new non-competes going forward as of September 4th, 2024, going forward are completely banned. Any existing non-competes, except for executives, which are defined as those making $151,164 or more and are a policy-making role in the company, those can still stand if they're existing. Any existing non-competes for all other employees, they need to be notified that they are now unenforceable as of the effective date, again, September 4th. Now, this is through the Federal Trade Commission. There's tons of information on the FTC website. There's a frequently asked questions page. There's even model language around how to reach out to former employees, current employees, anybody who has been given a non-compete and is still under that non-compete. They need to be notified that as of the effective date, it is unenforceable. Again, the exception to existing non-competes is that executive group. But as of September 4th going forward, all non-competes are banned. So we really recommend that you look at your handbooks, your agreements, all of your policies, take out your non-compete language, and really focus on non-solicitation and confidential information, proprietary information. Those are the policies that we need to focus on to help protect both the employees and the employer. Now, I know this is a lot of information. These are big changes. Again, they apply to every company. There aren't very many, if any, companies that are exempt from this. So please, please, please reach out to us. If you're a current client, reach out to your HR business partner if they have not reached out to you already. If you are not a client and have questions, feel free to reach out to us. We're happy to help you with this. There were a couple other federal regulation updates. There was a final ruling on the already existing Pregnant Workers Fairness Act that applies to companies with 15 or more employees. So that's also something to keep an eye on. And there was also a final ruling on the harassment regulations under Title VII under the EEOC. So there's been some expansion on that. So a lot of activity at the federal level. And again, at the federal level, that means it applies to essentially everybody, unless there is a headcount requirement like the Pregnant Worker Fairness Act for 15 or more employees. Anyway, just to wrap up real quick, Fair Labor Standards Act, salary minimum threshold, compliance deadline, July 1, 2024, non-compete ban deadline for compliance, September 4th, 2024. If you have questions, let us know. You can email me directly, Deanna at employersadvantagellc.com. Thank you.